So, my name's Sophia Long. I'm Senior Deputy Attorney General, and it seems like you've made it to the last presentation of the day. So congratulations. So it seems like the baton's been passed to me. I'm the final person. So apparently you get me as your anchor in, this thrilling educational marathon. So for the next hour, we're going to discuss disciplinary hearings and procedures. Now, which my part will really be geared toward the members from licensing boards that handle disciplinary actions during your public meetings. So I know it sounds nerve-wracking, but between your board counsel and the next hour, you should really be able to handle administrative hearings like a pro. So a few, I guess, ground rules to get started. When I say disciplinary hearings, I mean disciplinary hearings, administrative hearings, contested cases. These are all the same thing. So the same as boards, commission, state agency, regulatory body, these are all the same thing. And then there are areas where I may say something like your laws or your practice act, your statutes, these refer to your specific governing laws. For example, such as massage therapy, their governing law is NRS or NAC 640C. So that's what I'm referring to. So let's begin. So first, the basis for how to conduct administrative hearings is usually found at two statutes. It's either the latter part of 233B, and then for most licensing boards, it's NRS 622A. So these statutes for conducting administrative hearings really is an addition to and not instead of what's required for the open meeting law under NRS 241. So we'll go through the important provisions that pertain to you. But you should at least have a good thorough reading of NRS 233B, again, the latter part, and also NRS 622A for conducting administrative hearings. So first, here's the long, boring definition of a contested case. So it says it's a proceeding in which the legal rights, duties, or privileges of a party are required by law to be determined by an agency after an opportunity for hearing or in which an administrative penalty may be imposed. So there's your authority. So now let's just go through a few takeaways. So the legal rights or constitutional issues. So first, we have a bad actor. So why can't we just go and take the license away, right? So we see that this Gilman case helps us to see that a state-issued license to practice a profession carries a constitutionally protected property interest. So really that means that due process attaches to that license, which means that it prevents the state from just automatically taking away that person's license without taking some certain steps. And then there's one exception, which we'll talk about in a minute. So then, what is due process? So if you're going through this timeline, so normally what happens is that your board staff will be notified that there's a bad actor out there. They'll investigate, determine whether they believe a violation has occurred. And if so, then they'll send the information to the prosecuting attorney for your board. The attorney will file a formal charge, and that document will either be charged something like a charging document, an accusation, or a complaint. And then the complaint will ask the board to assess some sort of disciplinary action, or what's called an administrative penalty against the licensee. So now here's where due process really kicks in then. So before you assess any sort of administrative penalty, or even try to take someone's license away, you do have to provide three things to the licensee. And I've conveniently highlighted them for you on this slide. And that's reasonable notice, opportunity for a hearing, and an impartial adjudicator. So what belongs in the notice? According to 233B, we can see that these are the contents of the notice and it's really everything you should see in a complaint. So you'll always see a paragraph regarding the board's jurisdiction, the factual allegations that if they're proven, they lead to a legal violation, the request that the board do something to the license or that property interest, and then when and where the administrative hearing will take place. So the board is really looking to take some sort of adverse action against your license. So then now we have to provide the licensee reasonable notice of the notice. So due process requires that this reasonable notice is reasonably calculated under all the circumstances to inform the licensee of the administrative hearing. So then remember I said that these requirements are in addition to open meeting law. So if we look at 233B, which is for hearings, and then if we look at NRS 241, which is for open meeting law, reasonable notice. So if we put those together, it says reasonable notice can be done by sending a copy of the complaint to the licensee to the a copy of the complaint to the licensee by certified mail, not less than 21 working days to the licensee's last known address that the board has on file, or personal delivery not less than 5 working days before the administrative hearing. So then it's always a good idea to send an extra copy by regular mail. So then there's 2 things to keep in mind. So first, sometimes you do know that a licensee has moved, so either out of town or they just don't live at the same place as the address they have on file with the board. So just send the notice to the address you have on file anyway, because that is all that due process requires. And also most boards have a regulation that it's the licensee's responsibility to keep their address current with the board. And then the only exception to this I would recommend is that if you do know the specific address, the new address, even though the licensee didn't change it with the board, I'd send a copy there as well, even though it doesn't have to be certified. And you also don't have to, go out looking for it. So for example, if you send mail and it came back with a forwarding address, just send the notice to the forwarding address as well. And then courts have said that this is really a small step in protecting due process. So then second, if your own practice act, they may have some sort of specific provisions. So although under open meeting law, it may say that you need to give notice not less than 21 days before the administrative hearing. Your own practice act may say something different. It may say something like, 30 days before the administrative hearing. And at that point, your own practice act will govern. So here's an example from the real estate division. So not only do they have to give not less than 30 days notice, but they also have to give all relevant documents. And then also keep in mind, is this going to be a virtual hearing? So are you sure the respondent was provided with a good working link for the notice? And is that link able to be passed on to their witnesses? So one thing you cannot do is rely on the link that's on the agenda, because that's not proper notice. And also, if you provided either a broken link or a wrong link, you may have to start this whole process over, or at least get the respondent to a portion of the notice in order for you to move forward. Okay, so I mentioned earlier that there's one exception to due process. And this isn't really an exception, it's just more kind of like a bird walk, and that's summary suspensions. So summary suspensions can be issued if the board finds that there is a direct threat to public health, safety, or welfare. So it permits the board to immediately stop the licensee from practicing via a suspension. And when I say immediately, I mean immediately, like as soon as it's served. But again, this is only a temporary measure. So then due process requires the board to actually adjudicate the case, and that's specifically that they need to bring the licensee to hearing within 45 days after the suspension was issued. So that 45-day requirement can be waived by the licensee, but be sure that if the board decides to do this, that it's at the licensee's request, that it's in writing, and that the writing includes that the licensee will not practice until this matter has been concluded by the board. So summary suspensions are usually just issued by the chair. The entire board doesn't have to meet, and the chair does not participate in any other hearings or motions or anything in this case. And then when you serve the suspension is also served along with that notice and complaint of that actual hearing that the board's going to hold. So these are some of the factors to consider whether to issue a summary suspension. So remember, these suspensions are reserved for the most egregious actions, which means it should not be the norm. So for example, I have a board, it's the administrators for long-term care facilities. So if they have a bad actor there, it can cause irreparable harm to some of the residents. So for example, if they're prevented from getting medication, getting medical attention, there's physical harm being done, there's residents being neglected. So these are things that can actually rise to an emergency situation and can be ripe for a summary suspension. But what's not good for a summary suspension is if your main reason is financial. So either monetary gain or loss has never been deemed an emergency situation. Okay, so the second requirement for due process is opportunity for a hearing. And what that simply means is that the board will conduct the administrative hearing. They'll provide a means for the licensee to defend themselves with witnesses, exhibits, counsel, the right to confront and ask questions, and just really present their side. So as a side note, the right to counsel means counsel in good standing, licensed to practice in Nevada. Okay, so if someone ad hocs in, that's fine, but no out-of-state counsel, no Nevada bar suspended attorney, no paralegal, not your interpreter. Okay, so these are all examples of counsel that I've actually had to address in the past. So the last requirement is an impartial adjudicator. So the board actually does have a duty to be an impartial adjudicator. So that means you'll keep an open mind. You'll make a determination on the case based on what's in the complaint and in the evidence presented at hearing. And it means that you won't go out and do any investigations on your own into the case or contact any of the witnesses or parties. And it means that for all the reasons that you would recuse on any other matter before the board, you would also do the same at an administrative hearing. So, and as you can see from the Stivers case, that every member of the board needs to be impartial. Otherwise, it can lead to due process violations. So most of what we've talked about now has been handled by either your board staff, your board attorney, and it's all of this is done before you even know about the case. And again, that's because you, as deciding the case, need to be an impartial adjudicator. So then if we go back to our timeline, the licensee has been noticed. There's an actual date and time for the administrative hearing. You too now have notification that there is a complaint against the licensee. So at this point, usually both sides are getting together to see if this contested case can be resolved without going into a full hearing. So if this is the case, you might be presented with documents that either partially resolves a case or fully resolves a case. But either way, the dialogue is a benefit to both sides. So if this happens, in order to have a partial resolution of the case, you'll either see a stipulation of fact or a stipulation of fact and liability. So starting with the stipulation of fact. So this means that both sides agree to a specific set of facts to present to the board, and then typically there's no other documents or testimony or evidence that'll be considered by the board, and they either accept the stipulation of facts or reject it. So then with this set of facts, if it's accepted, each side will argue whether these facts lead to a violation. Then the board will vote whether a violation occurred, and if they voted that one did occur, then they can vote on the appropriate discipline. And then at the discipline phase, the parties can still recommend what they believe, is a discipline that could be imposed. So then there's a stipulation of facts and liability. So this is when the parties agreed to a specific set of facts and that these facts actually led to a violation or violations. And then the board accepts this stipulation or rejects it. So here the parties have agreed that that a violation has already occurred. So the board only needs to assess discipline. So again, the parties will be given an opportunity to recommend what they believe what discipline should be imposed, and the board will have that vote. So as you can see, like in these partial resolutions, the board still has a few decisions to make on their own. And then there are documents that fully resolve the case. So first, let's talk about stipulations for settlement or settlement agreements. So the settlement agreement will include everything. It'll include a specific set of facts, violations, and discipline that both sides have agreed to. So the board only needs to determine whether to accept or reject the settlement agreement. And if the board accepts the settlement agreement, and then the case is resolved and you're done. If the board does not accept the settlement agreement, then the parties can determine whether they want to come back and present the board with a new settlement agreement or go into a full hearing, usually based on the deliberations from, I guess, the current settlement agreement that was presented to them. But there is also a situation that if both parties are available at the hearing, the board can also request modifications as long as both parties accept the modifications in the agreement, so that it could still be accepted at that time. But one thing I would not suggest the board makes a habit of doing this, but every once in a while there may be a set of facts that doesn't sit well with the board, and they may feel that a little bit more discipline may make the settlement agreement a little stronger, or they would feel better with, a little bit stronger discipline. So a few things to remember is that settlement agreements, they actually are discipline. It's public, it's reported to any national data bank, and that they must be approved in a public hearing. So, kind of still talking about settlement agreements, I know they're challenging for some board members because sometimes the agreements are written to say something like the respondent doesn't contest the violations, or that the respondent admits the set of facts may lead to a violation. But we see what's noticeably absent is an actual admission of guilt. So this is fine, and there are many reasons a settlement agreement is written this way. So one is that in order for the board to impose discipline in an agreement, the requirement is just that the respondent must not contest the violations. And this is strategic, especially if there are other issues involved, such as, it touches on, another board has jurisdiction on part of this, or even if there may be some criminal liability. And as I said, this is a public document that may be used against the respondent elsewhere. And just as we've used public documents in the past, so if they've been disciplined in the past, we've used those discipline documents to impose discipline at this hearing. So it's basically they're preemptively protecting their rights, and that really is a valid legal maneuver. And another reason, and I think this one gives the board members a little more heartburn, is that sometimes the respondents, they may not really feel that they're guilty, but they're willing to accept the discipline. And that's also okay. So as long as the agreement is not worded that way, because again, the respondent cannot contest the violation. But if we think ahead, like what will actually happen is that if you go into a full hearing, you'll adjudicate the respondent guilty. And, and at the end, the respondent may not agree with you. And then you may assess the same discipline. So you've kind of taken the long route to end up at the same place. And another thing can happen is you go to a full hearing and the respondent prevails. So, either way, something else you've done is you've provided the respondent an avenue to also appeal the case. So it's another reason why settlement agreements say something like, in the interest of judicial economy, the parties agree to. And, and that judicial economy actually goes both ways. So you may not know until a hearing, again, that your case may have evidence problems. Not every witness is a good witness. You have stacked cases at a meeting. So, but I think best of all, settlement agreements is that there is no judicial review. So it means when you're done with the settlement agreement, you're done. It is not appealable. So if you ever take a look at the standard language in your agreements, the respondent will explicitly waive the right to appeal. So again, when I say you're done, you're done. Okay, so then there are other agreements there are other documents that fully resolve a case. And one of them is a voluntary surrender in lieu of other disciplinary action. So that is basically, what it says, that the respondent agrees to surrender the license, and also agrees not to reapply for a license for a certain period of time that's stated in that voluntary surrender, and then the board agrees that it'll take no other disciplinary action on this matter. And this voluntary surrender is either accepted or rejected by the board, and that usually resolves the case. However, if there are other cases or violation that the board has jurisdiction over regarding the respondent who surrendered the license, it's still, those other cases are still subject to the board's jurisdiction, and those other cases can still go forward. So voluntary surrenders too have also been upheld to be disciplined and to be reportable. So similar to any other applicant who's previously been disciplined, the board also doesn't have to grant the license if they choose to reapply. And then last, there's a temporary voluntary surrender. So usually if a respondent requests a continuance, the first one may be fine, but if they continue to keep requesting a continuance, what the board can do is ask that the person basically temporarily surrender their license or not practice until the matter is resolved. And also, sometimes I like to use this as a plan B to summary suspensions. So if a licensee's action is concerning, but maybe not rising to the level of an emergency action, you can try to negotiate a temporary surrender. And the last thing to remember about, all these pre-hearing resolutions is that the board can still ask limited questions based on the contents of the stipulation or the voluntary surrender. But be careful not to ask about specific details or specific facts of a case for a matter that's being presented to be, again, to be partially resolved or fully resolved. So if you have questions regarding, what questions you can ask a respondent or, regarding the case, please take the advice of your board counsel. Okay, so now we're on to pre-hearing motions. So pre-hearing resolutions, maybe during a hearing, you didn't have any, so now we have pre-hearing motions. So major ones you'll see is one of them is a request for continuance. And, the practice, of course, is that each side usually gets one. And sometimes like a respondent doesn't really get the gravity of the situation until the 11th hour, and sometimes they'll just come and say, you know what, I'm a little overwhelmed. I think I need an attorney, and that's fine. But if the facts of the complaint are really scary, you might want to discuss your DAG about what control options you have. Again, that is negotiating that temporary surrender or maybe limiting the license. However, at this stage, the respondent would have to agree to, anything that you try to impose on them. So then every now and then you'll get a request for discovery, depositions, interrogatories. So certain discovery is fine. It's not automatic unless it's specifically stated in the Practice Act. So remember, real estate, that was on that previous slide, they do have to provide all those documents to the other side. But sometimes you'll get an aggressive attorney who's never practiced in front of an administrative body, nor did they bother to look and see how you do it. So that's like my pet peeve. And they try to notice like depositions, interrogatories, and all that good stuff, file all these motions. So there's no need to be alarmed because NRS 622A.330 basically says those things really have no place in an administrative hearing. So you can feel free to respond with a no. So these are basically the two motions you'll probably see. There are others which your board counsel can give you guidance on. And I also find that usually the board chair has the authority to decide any sort of pre-hearing motions, but please consult your DAG and your own Practice Act because that might say your own Practice Act might say otherwise. Okay, so now preparing for the hearing. As a board member that's listening to the, that's participating in this hearing, just simply review the complaint, the notice provided to you, and an answer from the respondent if there is one. So, just briefly talking about answers. Unless your own Practice Act requires an answer from the respondent, you typically will not get one. And if you do get one, the answer generally will deny all allegations if it's prepared by attorney. And again, this is another legal maneuver. So, similar to that settlement agreement thing. You probably won't get an outright admission of guilt, but that's not really concerning because it's neither here nor there. But if you do get an answer that admits wrongdoing, that response is admissible in the hearing. So you want to review all the alleged facts based on the complaint, or all the alleged facts in the complaint. Check out the violations that they're being charged with, getting familiar with the law, and because all the evidence to support whether a violation occurred will be provided at a hearing, just be prepared to listen. And again, as an impartial adjudicator, try not to go out and gather evidence for yourself, whether it's talking to witnesses, looking up licensing information, all that good stuff should happen at the hearing. So the question is, who has the burden of proof at the hearing? So specifically you do, by way of your prosecuting attorney. So if you believe a violation occurred, it's up to you, basically by your attorney, to prove it by preponderance of the evidence. So on the slide is a long legal definition of preponderance of the evidence. And what it simply means is that when you're deciding guilt, all you have to think is it more likely than not that this violation occurred? So am I at least 51% sure that this violation occurred? So let's go back to our timeline. So the licensee, which is also known as the respondent, has been noticed of the complaint. You've done your duty and you've reviewed the complaint, familiar with the law. There's no additional research you've done. There are no pre-hearing motions, no pre-hearing resolutions, and now comes time for the hearing. So the chair calls a case and the respondent is not present. And this is what's known as a failure to appear in an FTA. So the statute does allow a board to proceed with a case without the respondent being present, but only if two requirements are met, and that's proper notice and that a continuance has not been requested or granted. So your attorney will provide proof. If the board is satisfied, not only can you proceed with the case in its entirety, but the statute also allows the board to accept all the facts in the charging document or the complaint as true. So that's what's considered a default hearing. So in default hearings, it's up to your attorney whether they want to submit the case to the board and go right into deliberations and decisions. Or the attorney still can present further evidence to the board before making that determination. So because it's a default hearing, it is an actual hearing. And if the respondent suddenly wakes up, and like they usually do after you send them notice of the outcome of the hearing or that their license has been revoked, they still have the right to appeal a default hearing. So personally, I feel as if since I already did the work, I like to at least put the documents in the evidence and provide testimony of witnesses because they did take time out of their day to show up. And although technically, if the respondent received proper service, the appeal should be denied, I also like to show the court that the board did, in fact, take time to actually hear the case before making any sort of disciplinary decisions. So another thing about default hearings is that the board will usually have a stack calendar, which means, as you know, there's a few contested cases noticed for that day. So for example, if we say there's 5 cases and 3 of them are FTAs, so you're going to perform a default hearing. So I know it seems tedious to open a hearing, listen to the offer of proof of service for 3 separate times, only to determine the proof of service was sufficient 3 separate times. But as I said, default hearings are actually hearings that they can be appealed. So that means the board needs a full and complete record in each and every FTA. Otherwise, you're kind of at risk of having your default overturned, okay? So the court can't look outside of the case to public comment to any other case. Everything you need has to be on a self-sustained record to provide to the court. So just treat every FTA as if it's your first one or the only one. Okay, so if we have a situation where the respondent woke up the day of the hearing and decided to attend, this is the outline. The procedure to basically open the hearing before you turn it over for the parties to speak. So I think most of you may have a board chair script that our office gave out a few years ago. So this outline really isn't much different from that. So now that we're at the hearing, the chair does control the hearing. So usually makes all the rulings needed, okay, such as the introduction of evidence, objections, all that good and lovely stuff. So along with opening the hearing, the chair will usually ask for any preliminary matters, and this is if there's, any of those motions, any stipulations such as stipulation of fact, stipulation liability, anything like that. And then we get into the hearing. So swearing in the witnesses, and there doesn't need to be a lot of time done on this, and it doesn't matter who does it. It could either be the chair, the court reporter, the DAG, and there's also no rule as to how it's done. So you can get all your witnesses together and swear them in individually, or swear them in together, or you can swear them in individually. So a few things to remember too, that, if you have a witness testifying and you forgot to swear them in at the beginning of their testimony, you can still do it at any time. It's fine. And then hopefully on a very rare occasion, or it does not happen, is that you forget to swear a witness in entirely, and you still don't have to worry about this. Because at the end of the day, the witness is still providing testimony in a legal tribunal. So there still is consequences if a witness is not being truthful. Okay, so this not swearing them in is not any sort of loophole or any sort of gotcha moment or anything like that. So I have on here too that anybody else should be sworn in as well, especially an interpreter. And there's the swearing in language for the interpreter. And on that subject, according to NRS 233B 1235, the board is only obligated to provide an interpreter for the deaf or hard of hearing, and that's part of the OML as well. So that means, that sometimes a respondent will come with their own interpreter, and it's either a friend or a spouse or whoever. And technically this interpreter should be a certified interpreter, but usually it's fine. Just swear in their interpreter and then be on the lookout for conversations between the interpreter and the respondent, right? So this leads to pretty much the friend interpreter, giving advice while interpreting. So you may need to give the interpreter further instructions that they should only be saying what the board says and then what the respondent says. So even if the respondent says something like, I don't understand, their interpreter should just interpret that. So another issue we had is if a spouse is acting as an interpreter and the spouse is still sworn in just to interpret. But sometimes whatever, the situation, whatever's going on in this hearing will most likely affect the spouse as well. So if they need to converse, just take a break. They shouldn't be conversing while the spouse is trying to interpret, but just have them take a break. When the hearing's going on, the spouse should only be interpreting. And then a last kind of opening the hearing matter is that the parties have a right to ask that witnesses should be excluded from the hearing unless testifying. And this is different from a closed meeting because it only pertains to witnesses offering testimony. So I actually just had this happen at one of my boards. And it was virtual. So be prepared if it's virtual. So is there a virtual waiting room you can put the witnesses in? If they need to disconnect, is there a phone number you can call them in order to get back on, to reconnect and get back on the hearing? And, and another thing is to make sure that if the witnesses are off the hearing, make sure that you give them an instruction that they are not permitted to talk to each other. I guess regarding the hearing. So here's the order of the hearing. And this is similar to the outline, that's the board chair script, and it's basically a roadmap. If you have a respondent representing themselves, it's a good idea to kind of go through this roadmap, inform them of it, so they at least know when they can speak, when it's their turn to speak, what they can, what they cannot do. And don't forget that board members can ask questions during the hearing as well, whenever it's the board's turn. So now we have evidence. There's going to be evidence presented. So when we think of introducing evidence, the evidence should be reliable and relevant. So whether it pertains to documents or testimony, even tangible objects. So an objection you usually see is an objection to foundation, and that just simply means that the opposing side doesn't believe the document is reliable. So for example, if we're looking at copies, how are we sure that these are true and correct copies of the original? So evidence is going to be presented at a hearing. For in-person hearings, documents or tangible evidence can be passed around to the board. But again, if we have a virtual hearing, what can the board do? So the board needs to prepare how they'll get the evidence to the board to be admitted into the record and also to the other side. So is this something like via Dropbox, an email, a screen share, which I believe should be the last resort? Or, the parties can also just agree to a set of evidence that can be provided to the board prior to the hearing too. So again, as you can see, if you're going to conduct a virtual hearing, there needs to be a lot of preparation taken in order to avoid, certain hiccups. And then of course, there's evidence that's omitted, and then there's evidence that you really should exclude. And that specifically is irrelevant, immaterial, or unduly repetitious evidence. So that means, basic whatever is being sought to be introduced really has no bearing on the case. And then there's also privileged communication, and that's evidence that's just precluded by law. So one thing is your board counsel can help you navigate this type of evidence, because sometimes it's easy just to accidentally even ask. So for example, if a respondent answers a question and then you ask something like, did your attorney tell you to say that, right? So we can see that that's attorney-client privilege. So during the hearing, if there's witness testimony, you'll need, and most likely it'll be conflicting testimony on either side, so you'll need to assess the credibility of witnesses. So these are some factors that you should take into account when listening and assessing that credibility, right? So was the witness able to see or hear everything that was going on? What's the witness's ability to recall things accurately and describe those things? What's the manner of testifying? Is there any sort of bias or outcome that the witness has in the hearing? And then how reasonable was the witness's testimony considered in light of all the evidence in the case? So there's a lot of, so you really should include a lot of discussion regarding the credibility of witnesses when you deliberate. And that's especially certain if you're stuck in a he said, she said situation. So during a hearing, you will most likely get the dreaded hearsay ejection. So figuring out where hearsay is, to me, sometimes feels as elusive as that offsides rule in soccer. So here's the exact definition. It says that hearsay is an out-of-court statement offered to prove the truth of the matter asserted. So it's basically a witness trying to establish a fact by being told the fact. Instead of, remember, again, a witness should have either personal knowledge or personal observation of the fact. So there's the example here. I had another example, and this can happen. So I had a case where we had a night manager who was sexually harassing a bartender. And every morning that bartender would go and complain to the day manager of the harassment. So finally the bartender quit and the day manager informed legal of the sexual harassment. So by the time the case came ready to prosecution, we only had the day manager as a witness to establish whether the harassment occurred. So here, we're trying to prove the truth of the matter asserted, right? That the sexual harassment did in fact occur. The witness will testify that every morning he was told about the harassment. So even when we tick all those credibility boxes for the witness, this testimony is still considered hearsay because there was not a personal observation. So even though he was a credible witness and the statement may seem credible, it is still considered hearsay. So the main takeaway regarding hearsay is that although in court hearsay is not admissible, in administrative hearings, hearsay is admissible. So when you hear those hearsay objections, as long as the testimony seems reliable and relevant, then most likely you should admit it. However, the caveat or the very important part is hearsay alone, especially to establish an important fact, again, whether that sexual harassment occurred, is not enough to prove the fact. Okay, so as it says on the slide, that evidence must consist of more than hearsay. So again, in this example, if all you have is a day manager's testimony, then that fact has not been proven. Okay, now we're done with hearsay. And we're on to objections. So we've discussed objections a little bit. And again, the chair will make the determination whether overruled or sustained. And I know it's hard to remember these legal terms. So anything to convey what you mean is acceptable. So for example, if the chair just says, I'll allow it, we know what that means, or no, just move on, we all know what that means. These will do fine. And there's my keyword, is overrule. So you do want to hear the objections and keep a record of the objections. So again, if someone's making an objection, why the objection is made, if there's an argument to admitting whatever it is, the evidence, they should also put that on the record. If you have any questions regarding objections, again, seek advice from your board counsel. Another thing that's important is not to leave objections hanging. Sometimes after there's an objection, an attorney will just go ahead and ask the question different. So, just make sure that we know kind of what the ruling on that objection is then. Or sometimes they'll just withdraw the question, and that's fine as well. So again, just make sure there's a resolution basically to all these objections. Okay, so again, we see this theme that the board as impartial adjudicators should not be conversing with parties or a witness to the case outside of the case. So, it's one of the reasons that we see on the agenda, the notice that reads something like, prior to the commencement and conclusion. Sorry, let me find it. Prior to the commencement and conclusion of a contested case or quasi-judicial proceeding that may affect the due process right of an individual, the board may refuse to consider public comment. Okay, so I think that's on pretty much every board's agenda at this point. So basically, when someone's trying to offer unsolicited testimony outside of a hearing. So not only is that not in the record, but it can influence the outcome of the case. So even public comment can be considered ex parte communication. So that's why we don't want anyone talking about a case before the case has really been decided. Okay, so post-hearing deliberations. So now we're back to our timeline. The parties presented their evidence. They made their closing argument. And now the matter is now submitted back to the board. So we're at the point at the hearing where what's called the evidentiary portion is over. So the board now deliberates amongst themselves whether substantial evidence established that the respondent has committed a violation of law in the complaint. Okay, so I say substantial evidence, and that is different from preponderance of the evidence. Okay, so remember, preponderance of the evidence is your burden of proof, that in the end, you're more sure than not that a violation occurred. So what substantial evidence refers to is a quality and quantity of the evidence necessary to support factual determinations. So something to support factual determinations can be circumstantial evidence, and that's evidence that relies on an inference to establish a fact. So I actually think that this cartoon illustrates substantial evidence very well. So another example I have is that if somebody walks in with a wet umbrella, you can conclude that it's raining outside, right? So the evidence is strong enough to establish a fact that it's raining outside. And this is really just a hair shy of personal observations. And substantial evidence also includes your own personal knowledge. So most of you are in the industry that you're regulating. So for example, if you're an architect, can you look at the plans that are before you and tell if something's missing or something's wrong? If you're a nurse, can you tell that the respondent didn't follow like safe procedures when tending to a patient? So deliberations, keeping a good record of deliberations. So this means that the board should have a healthy and robust involved discussion about the facts and evidence that's before them and have a clear record of deliberations. You may think that this is a slam dunk, but you still need to have the discussion. So again, why you believe one witness over another during conflicting testimony, why one document or evidence is more important than another, why you can tell from the respondent's testimony that they did not follow those safe nursing procedures when tending to a patient. So from analyzing and discussing the facts, examine the violations. Do the facts rise to the level that a violation occurred? One violation, all of them, some of them, none. Again, healthy, robust deliberations. And here is something else to keep in mind. That sometimes during a hearing, the board finds that the respondent violated other aspects of your laws. But you are only allowed to consider the violations that are alleged in the complaint. And why is that? So again, if we go back to this due process, the respondent was only given notice of the alleged violations in the complaint. And a complaint can't be open-ended, such as charging these violations and then whatever we can think of later, okay? So a full and clear record of deliberation is just as important as that due process. One thing is, without it, it can seem that the board is making these rogue and arbitrary and capricious decisions based on, who knows what. So we're almost done with the hearing process. So we're almost done with the hearing process. So at this point, we've rounded the bases, we're about to slide into home plate. And in order to fully adjudicate a case, you're gonna need some votes. So here, I know every board seems to do a different number of votes. One thing I like to start with is simply whether or not the evidence proved a violation or violations occurred. So the vote will be something like, I move that respondent violated counts 1 through 3 of the complaint, or that respondent violated counts 1 and 3 of the complaint, which means you found the respondent in violation of something, so now you can assess discipline. However, I do know some boards like to accept the facts alleged in the complaint first. I personally don't. And that's because with a robust discussion, it should be clear what the board facts and clear that those facts led to a violation. And then sometimes, I've noticed the facts in the complaint are just wrong. So I just find it a necessary step. But it doesn't mean I'm right. And actually, if you are a board or an attorney that suggests to your board to accept the facts first, feel free to say so in the chat and why you do it. And as Homa said, I think that the chat allows you even to submit it anonymously if you don't want me to know who you are. So discipline imposed. So similarly, as full deliberations on the record as to why there's a violation, there should be a full discussion on the record as well as far as the discipline that you will impose. So things to discuss is that, is this case similar to other cases? What did you do in those other cases? Are you being consistent? Are there mitigating or aggravating factors? And also remember to discipline according to your statutes. So are you trying to order something like community service when your statutes don't authorize it? You know, there was a board that ordered and even kind of put it in their settlement agreements a little bit ago that the respondent is to contribute a certain amount of money to a nonprofit in their industry. And they do this for several years. And after being audited, they were shown that they really didn't have the authority to do this, you know, so as noble as it may seem. But some statutes some statutes also have a provision that says that you can do something like reprimand, fine, probation, and language that basically says something else. So if it does, I wouldn't interpret that something else too loosely. So as you know, any fines assessed to the respondent has to go to the general fund, but the board can recover the actual costs and fees associated with a contested case. So the recovery of costs and fees have to be approved by the board after they've had an opportunity to review an itemized statement and provide that statement, you know, especially the attorney's fees to the respondent. So the respondent can object to anything on the statement, you know, basically since they're going to be paying for it, and the board can make a determination as far as what to do with that. But if the board does vote to recover costs and fees, the motion should include language that they have actually refunded the costs, they're awarding X amount of dollars, and that they consider the cost to be three things, and that is necessary, reasonable, and actually incurred. You know, so again, for me, my boards at the most usually do votes regarding, or basically 3 votes. So it's regarding the violation, the discipline, and then costs. So, you know, based on your board, it could be more or it could be less. Okay. So now, if the board has to revoke someone's license, just keep in mind that the revocation has to be at least a year. It can't be more than 10 years. And when the licensee comes back after a revocation and applies for a license, it doesn't mean that the licensee is automatically granted a license. So for me, this is important because sometimes I see boards that want to see, for example, a 5-year revo rather than the 3-year. So, but either way, in reality, it may take way longer for them to get another license. But what is important to me at that moment is that the bad actor is no longer practicing. So when the hearing is over, there needs to be a decision or an order issued. And this is by way of a finding the facts and conclusions of law, which will be stated separately. The document will be in writing, and that's basically the order from the hearing. So your board counsel or attorney will draft it. It'll be signed by the board chair or the person presiding basically over the hearing. And you'll see specific language that the facts met your burden of proof. So specifically that the facts were supported by preponderance of the evidence. So simply, you know, after you do your order, it's reduced to writing, it's signed, it'll be served on the respondent within 60 days of the hearing. Okay, so this is just a reminder that it's the board's duty to develop a full record. So making sure all the exhibits are included, the record's clear, the witnesses and parties weren't talking over each other, any motions, including objections, have a clear ruling. And of course, again, that robust deliberation that supports the decision. And part of it is because of an appeal. So some practice acts pretty much say that if the respondent wants to appeal the decision, it has to go to another administrative body. So for example, if you used a hearing officer, the board may receive the appeal. So I know this is the case for the taxi cab authority, that any sort of appeals from a hearing officer goes to the commission. So this has to be done before it goes to district court, because, again, essentially you have to exhaust all your administrative remedies first before you can go to court. So if a respondent goes to court to appeal, it's pretty much what's called a petition for judicial review, or PJR. But there are timing limitations, and these are usually strictly enforced, okay? So the court's not until, the 3 strikes, you get no second serve, you get no free kick. It's, either you met the deadline or you didn't. So now the burden of proof is not necessarily yours anymore, but it's whoever decided to do the appeal. And then regarding appeals, it's understood that if a PJR is filed by a respondent, the board will respond. So, it takes time for a board to have a meeting, and then if a responsive deadline may come in the interim, you're kind of already 8 seconds into overtime now, right? So the board attorney can go ahead and respond, basically, to keep the board in the game. But if the board wants to appeal a decision, and whether that's to district court or whether that's to the Nevada Supreme Court, that this has to be done in a public hearing and with board approval. So it's also important to note that a board order is enforceable unless the court has granted a stay. So if a respondent wants relief from the board order while the action is pending in court, that you'll most likely get served with a PJR and the motion for stay at the same time. Okay, so we're finally at the last slide. So briefly, remember I said that facts should be supported by substantial evidence. And substantial evidence is a standard of review. And remember, it's whether the facts found whether the facts that were found, by the board are reasonably supported by sufficient worthy evidence that's in the record. So this is a standard of review that the court will use to determine whether they need to take action regarding your order. So the court will look at these factors, that's pretty much listed on the slide. So here's the theme again. If they find impartial adjudicators with a clear record, robust deliberations, they usually will not disrupt the order. So we're kind of at the conclusion of the procedure for administrative hearings, but I just wanted to conclude that this is my foster puppy, Marcus, and he was just adopted yesterday. And as you can see, he used to be a bit nervous about administrative hearings too, but after listening to this presentation, since he was my only practice audience, he's now ready to tackle administrative hearings like a pro too. So with that, thank you for toughing it out until the end. And I think we have a few minutes for questions.
Yes, we do. So we've got a question. What about payment of witness fees for subpoena of a non-party witness in a disciplinary hearing? And then it's a 2-part question, but it also goes on to say, does this payment of witness fees have to be paid at the time of service of the subpoena or at the hearing? Or is there some other provision that the state agency is exempted from the payment of those fees?
Okay, so can we start the question over? Sorry, Homa.
Yeah. So it's talking about payment of witness fees for the subpoena of a non-party witness in a disciplinary hearing. So I imagine in a non-disciplinary hearing, right? You have a non-party witness, you always have to pay like a fee, but the question is, does that fee have to be paid at the time of service of the subpoena or when they show up to the hearing? And then is there an exemption for a state agency to not have to pay that fee?
So, that is a good question because, I assume we're talking about witnesses for the state instead of, of course, we're not paying fees for witnesses for the other side. Actually, that is a good question because as far as the cases that I've done, I've never had anybody that wanted payment. I think especially when you have complainants who filed a complaint with the board, they're not looking to get paid. What they're more so looking for is just, some sort of discipline resolution to pretty much the harm that was done, to the person who caused them harm. So.
Well, I guess the question includes a citation, and I just pulled it, and that's specific to pharmacy. It talks about that the board, it says here, subpoenas must be served in such and such way. And I believe that the issue might be that the subpoena itself may be deemed invalid if it isn't accompanied by the check. I know in regular civil practice, I always would send a check. Sometimes people wouldn't cash it, right? But if it wasn't included, of course, on the state side, I don't fight subpoenas for my client that are missing the witness check, right? It's kind of a gotcha. But the statute they cited was NRS 639.246, and it indicates that witnesses appearing pursuant to a subpoena must receive expenses in the same circumstances as prescribed by law for civil actions. And I do know the civil action rule is the witness check should accompany the subpoena. So I guess that would be some.
Sorry, go ahead.
It's what?
So I was just going to say that sounds good, because again, if they're citing to a specific practice act, then again, always check, your own governing statutes as far as what to do. So, I mean, if that, if it pretty much dictates that you pay your witness, then pay your witness and sorry, I didn't catch, your entire reading of the law, but if it has to come with the check, then it comes with the check.
Okay, so I guess the answer is, yeah, look at anything specific would overrule the general in that situation. And then the same question asker indicates your puppy is adorable. Oh, which, yes, this is correct. And then one commenter had said that if they agree that if a full hearing is on the merits, the facts would already be in the record. They personally like to summarize a little bit, maybe what would be in support. I guess it seems like that's a personal preference or style preference depending on the case, correct?
Yeah, that sounds good.
Okay, so another question we've got is if board members jump to the discipline issue in deliberations, should their counsel direct them back to the facts, either to make their findings or discuss them more thoroughly?
Well, to me, yes. So if it was my board, I liked, again, trying to keep that clear and concise record. If you're first, before you can even get to discipline, you need to find a violation. So I'd rather have them have that discussion on a violation first and then discuss the discipline.
Gotcha. And then another question is, does a licensee have a right to the in-person hearing if the board wants to make it virtual?
So yes and no. So one thing I would do is, again, there needs to be a lot of preparation for virtual hearings, and even now hearings like this. So are there things that you could negotiate with? And for example, I know some of my boards that, after COVID and they didn't have to have an audience in a room, and instead of using a government meeting place, they pay for it. So now they don't have to pay for a massive room to hold the audience, right? But they still have board members together in a room. They just don't pay for, again, a big room, just now they pay for a room that holds the board members. So for example, can you bring the respondent, can you just have that hearing done in person in the room? I mean, the public is not, the public is virtual. Can you do kind of a hybrid? Can some of your witnesses, be virtual? Can just the attorney and the respondent be in the room? So I would have basically a conversation with the other side as far as how to conduct the hearing.
Gotcha. And kind of related to the virtual question, do you find, how are you finding it challenging, like if you have to invoke an exclusionary rule when it is virtual, like to make sure that a witness isn't also attending like via a public mechanism, like they aren't watching but when they're not testifying virtually?
Yeah, so again, the assumption is that they are, if they have to disconnect, or if you put them in a waiting room, they are going to be in the waiting room. But yeah, again, that's why you need preparation.
Yeah, there's another question. Does it matter who swears witnesses in for these hearings? Should it be the chair, or does it have to be a court reporter?
No, so it could be the chair, it could be your DAG, it can be the court reporter. No.
Okay. Let's see, there's two more. If there's no specific notice requirement in the Practice Act, is it safe to assume 30 days is sufficient under 233B?
So I would assume 21 working days is sufficient, and that's under that open meeting law. So open meeting law, I think it's 241.033 or 032, that you are going to talk about a person's character. You're going to talk about some of the bad acts that they did. So they need not less than 21 working days notice, or if you're going to personally serve them, 5 days. However, I would say if you personally serve someone 5 days prior to the hearing, you can guarantee that you're going to get a motion to continue or a request for continuance.
Gotcha. Okay, so then we also got, if a board member doesn't have a personal or financial relationship with the case, but may have strong political or other opinions, what rises to the level of being biased such that, there'd be a due process issue?
Yeah, so I would say not just bias, but even an inference of bias. So that's up to you. If you feel that there's something else that doesn't automatically have to recuse you, but if you feel that you may be biased, just recuse yourself. It's fine. No one will fault you for it. Because again, we need impartial adjudicators. If you yourself feel that there's something that's going to prevent you from being impartial, please just recuse yourself.
Gotcha. And then are any of the noticing requirements waivable by the licensee?
Yes. So even for example, the 21 working day, and again, anything that's waived by the licensee should be done in writing. And to me, I feel like in writing is an actual document in writing. I don't mean like an email back and forth that says, hey, you good? Yeah, I'm good. Something that says, so I didn't get 21 working days. I got 10. I'm fine with 10. I'll still be off the hearing. We can still, move forward with this. I want this over with.
Gotcha. And then I don't know if it had come up already, but I was just going to throw out, I just had done a PJR case, and the Whitfield case. Did you get a chance to see that one? I can just summarize. What's really interesting, it talks about proper captioning and proper notice of parties. And so if anyone's working in this field, definitely have a look. It came out this summer, and it affirmed a decision in favor of our office that was kind of saying, well, you can't just randomly mention people in your petition for judicial review. You have to properly notice them so they can appear and that they can, handle it. But I thought that was really interesting, because I guess the person had attached the decision below, but didn't name, and think in that case, NDOC in the caption, and it was properly dismissed. So you were mentioning about how persnickety these rules are, because it's a jurisdictional requirement, right? Like if you miss that window, it's over. I was surprised just how much of a gotcha, because so much in law we have, oh, let's do this on the merits, right? But not in PJRs. They're like, bye.
Right.
Do not pass go, do not collect $200. It's over.
Yeah, I tried to throw in all my sports analogies that I knew to kind of drill it down. So I don't know if it took or not, but
exactly. Well, I'm going to pass it over to Rosalie to see if there's any more like just general questions or discussion. For those of you who are attending, you have had now 5 1-hour, sessions mixed in with your various breaks and stuff like that. So we do have a period for Q&A starting at 3:15, but if there are no questions, you have still now achieved your CLE credit if you've been with us since 9 this morning, right? Because we had an hour with Jeff and LCB, we had an hour with Rosalie, we had an hour with Leslie, we had an hour with a little short of an hour with Justin, but then Sophia brought us home and gave us a little bit of that 10-minute extra back. So I have sent out the link for the code word, where to put the code words in. And if you missed anything due to technical difficulties, then we will have brain. It's late. We will have the video on SharePoint, and we're going to work on how that will play out to make sure that anybody who had technical difficulties or had to miss a portion can get back up to speed. But if you just attended 1 or 2 and you want to submit your paperwork for that, please fill that out in the form and indicate what you have. So I'm going to hand the mic to Rosalie in case there's anything further, because I have to jump off for a client call. So thank you, guys.
I don't believe I have anything further, but I want to thank everyone for being here and thank our presenters as well for their hard work on the event today. These videos we're hoping to put up on the website, so if there's portions you missed, be in contact with us. We may be able to help with that. In addition, these will be available in general to public body members and other members of the public to view outside of the CLE credit front, but they should be available for general training to replace the videos from 2019 that are on our website. And I don't see any additional questions, so I'm inclined to end it here, but thank you again, everyone, for joining. And if further questions arise, feel free to contact myself or other presenters with questions.